Hello everyone, welcome to my YouTube channel Study with Riti. Today we are going to talk about doctrine of indoor management, that is also known as Turkan's rule. Okay, so what is doctrine of indoor management? The doctrine of indoor management is a legal principle in company law that protect outsiders, third parties who deal with company in good faith. What is this? It is a legal principle in company law. Company law 2013 we are talking about here. That protect outsiders. The doctrine of constructive notice protects the company. Doctrine of indoor management protects the outsiders. And doctrine of ultravirus is just a theory of working beyond your powers. ठीक है? Definition: if someone deals with a company and their transaction appears to be within the company powers, they are not required to check internal rules or approvals. The company cannot deny liability by saying its internal procedures were not followed. So लैंडमार्क केस है रॉयल ब्रिटिश वर्सेस टॉरकॉन का 1856 में, and that is why it is also known as Torkhan's rule. In the next video I am going to talk about this particular landmark case, but in this video I am just going to talk about the concept building of this particular topic. So this is first made so company does not misuse doctrine of constructive notice. Doctrine of constructive notice helps company a lot. But what about the outsiders of the company? They also needs a protection, right? And uske liye we got doctrine of indoor management. It assumes innocent outsiders. We assume कि outsiders की गलती नहीं है. Here we have the dealing with against the company. Not assumes, it is presume. मतलब यही बात है, innocent outsiders ही होते हैं. And they believe that the internal procedures were followed. They are not required to check internal rules or approvals. तो थोड़ी सी डीप बात करते हैं. Section 399 make your MOA and AOA as a public document, and anyone can inspect it with a nominal fees. एक nominal fees पे करके anyone can read MOA and AOA. तो the third party must do a contract, must make a dealing, must make a transaction after reading MOA and AOA. It is said that third party have read MOA and AOA already. So if they are doing anything ultra virus, if they are doing anything against the MOA and AOA, so both company and outsider means third party is liable. अगर आप कुछ भी बियॉन्ड MOA और AOA कर रहे हो तो इट इज सेड दैट बोथ कंपनी एंड आउटसाइडर इज लायबल बिकॉज योर MOA एंड AOA इज अ पब्लिक डॉक्यूमेंट. थर्ड पार्टी को पढ़ना ही चाहिए था, तो हम ये प्रिज्यूम करते हैं दैट थर्ड पार्टी हैव read MOA and AOA. अब थर्ड पार्टी ये नहीं कह सकती है दैट आई एम इनोसेंट, आई डिडंट रीड MOA एंड AOA. अगर आपने नहीं पढ़ा तो आपकी गलती है. हम तो यही एज्यूम करते हैं कि आप पढ़ के आए थे MOA एंड AOA, और अगर आपने कुछ भी बियॉन्ड MOA और AOA किया है, इट मीन्स आपने जानबूझ के किया. इट इज अ इंटेंशनल एक्ट, एंड व्हेन इट्स अ इंटेंशनल एक्ट मीन्स बोथ कंपनी एंड आउटसाइडर इज लायबल. अब इसी का थोड़ा एडवांस वर्जन है इंडोर मैनेजमेंट का, ठीक है। अब क्या होता है, तो इन अरे अरे ओके, सो doctrine of indoor management, what it says, let us read the definition again. It says that when someone deals with the company and their transactions appear to be within company powers. Company powers, within company powers means they have read MOA and AOA. They have read MOA and AOA and it appears that it is within the company's power. So they are not required to check internal rules or approvals. क्या मतलब है? Indoor management says that outsider has read MOA and AOA, and if that action, if the contract is within the power of MOA and AOA, तो उनको internal approval check करने की जरूरत नहीं. इसके लिए example है that the MOA of a company says that loan can be taken up to 10 lakh with approval of board of directors. So if this let's say ABC Limited and the bank did what? Read MOA and AOA. MOA and AOA पढ़ लिया because it's a public document. Public document का nominal value पाएगी. They read MOA and AOA and they read that okay, I can give loan up to 10 lakhs. And they did what? They gave loan of 10 lakh. And ABC Limited signed a contract to pay the amount. Means interest plus principal pay karega company. They sign this contract. What happens? The bank does not need to check. The bank read MOA and AOA. They read that okay, loan can be taken up to 10 lakh. So this time bank is correct. Bank did their job. But it does not have to check the approval of board of directors. बिकॉज अगर एमओए में लिखा है कि 10 लाख का लोन दे सकता है अप्रूवल ऑफ बोर्ड ऑफ डायरेक्टर, सो इट presumes, so the third party presumes that internal internal formalities are taken care of. तो बैंक जस्ट सेड कि 10 लाख का लोन दे सकते हैं. They gave the loan for 10 lakh. Now approval of board of directors में the bank presumed here that internal formalities are taken care of. This is their internal formalities. अब अगर कंपनी ने ये अप्रूवल नहीं लिया है बोर्ड ऑफ डायरेक्टर से, if they have not taken the approval of board of director, then your bank is not liable for internal formalities. Means इसने लोन दिया 10 lakhs का because MOA said it. Now approval of board of directors या internal formalities, and बैंक ने presume किया था that कंपनी ने तो कर ही लिया होगा इंटरनल फॉर्मेलिटी. बट अगर कंपनी ने नहीं किया है तो बैंक इज नॉट लायबल फॉर दैट. दिस इज द कंपनीज फॉल्ट ओनली कंपनी इज लायबल. बैंक का कुछ लेना देना नहीं है इससे, ठीक है. अब इसके लिए कुछ एग्जांपल्स है, विल रीड इट टुगेदर. ओके, इतना ही पे पढ़ते हैं. Let's say a company's article allow it to borrow money with board approval. A third party lends 20 lakhs to the company believing internal approval has been taken. This example is similar to this, right? Example 1 is same. Second example, share allotment without proper procedure. A company's article states shares can only be allotted after a special resolution passed by shareholders. तो एक कंपनी का आर्टिकल्स कहता है दैट शेयर्स को अलॉट करने के लिए यू नीड अ स्पेशल रेजोल्यूशन बाय द शेयर होल्डर्स. शेयर होल्डर्स को एक रेजोल्यूशन पास करना होगा तभी आप शेयर्स अलॉट कर सकते हो. नाउ द कंपनी इशूज शेयर्स टू मिस्टर जेड विदाउट होल्डिंग द रिक्वायर्ड मीटिंग. अब जेड को उन्होंने शेयर्स दे दिए. दे अलॉटेड द शेयर्स टू मिस्टर जेड. नाउ मिस्टर जेड क्या करेंगे? मिस्टर जेड बोलेंगे कि ओके आई रेड दिस आर्टिकल्स एंड इट सेज दैट शेयर्स कैन बी अलॉटेड आफ्टर स्पेशल रेजोल्यूशन. दिस स्पेशल रेजोल्यूशन इज योर internal formalities. So Mr. J does not need to check that special resolution हुआ है कि नहीं हुआ है. उन्होंने बस इतना पढ़ा कि ये shares allotment is legal. लेकिन अब कंपनी ने गलत किया कि they gave him, they allotted the shares to Mr. Z without holding the required meeting. अब मिस्टर जेड बाइज द शेयर्स इन गुड फेथ. मिस्टर जेड ने शेयर्स ले लिया थिंकिंग कि स्पेशल रेजोल्यूशन तो हो ही गया होगा. ही प्रेज्यूम्ड दैट इंटरनल फॉर्मेलिटीज आर टेकन केयर ऑफ. रिजल्ट, मिस्टर जेड इज प्रोटेक्टेड. मतलब अगर यहाँ पे अब लाइबिलिटी की बात आएगी तो मिस्टर जेड इज नॉट लायबल फॉर इंटरनल फॉर्मेलिटीज, ओनली द कंपनी इज लायबल. The company cannot deny his shareholding on the basis of internal irregularities. अब मिस्टर जेड को कंपनी ये नहीं कह सकती कि हम आपको शेयर्स नहीं देंगे क्योंकि इंटरनली उन्होंने गड़बड़ किया है. जेड को तो शेयर्स मिलेंगे ही मिलेंगे. थर्ड, कॉन्ट्रैक्ट साइन बाय एन ऑफिसर ए. Contract requires signature by the managing director only. The company clerk signs a contract without authorization. The other party had no reason to suspect the clerk lacked authority. Result, the company may be bound by the contract under indoor management unless the outsider knew or should have known about the irregularity. अब यहाँ पे क्या हुआ, एक ऑफिसर ने कॉन्ट्रैक्ट साइन कर लिया, कॉन्ट्रैक्ट, बट उसमें एक इंटरनल फॉर्मेलिटी वाज नीडेड that they should be authorization signs by the managing director, but he didn't follow the internal formality. But now the company is bound to this contract. Company is bound to the contract because the outsider presume that the internal formalities are taken care of. उसने सोचा कि internal formalities हो गई हैं and he didn't needed to check it again. So now the company is bound to outsider for the contract. उनको कॉन्ट्रैक्ट फुलफिल करना ही होगा. दे कैन नॉट बैक आउट द कॉन्ट्रैक्ट सेइंग कि हमने तो ये मैनेजिंग डायरेक्टर का साइन नहीं हुआ था इसमें. आउटसाइडर कहेगा कि व्हाट एम आई सपोज टू डू विद इट. आई एम नॉट लायबल फॉर इंटरनल फॉर्मेलिटीज. आई प्रिज्यूम दैट द इंटरनल फॉर्मेलिटीज आर टेकन केयर ऑफ. और अगर आपने अपनी इंटरनल फॉर्मेलिटीज नहीं की है तो उसमें मेरी गलती नहीं है. आपको तो ये कॉन्ट्रैक्ट फुलफिल करना ही पड़ेगा. कॉन्ट्रैक्ट हैज टू बी फुलफिल्ड. आउटसाइडर कहेगा करना ही पड़ेगा. अब इसमें एक बात ये आती है कि अब हो सकता है अगर आउटसाइडर को अगर पता था कि इंटरनल फॉर्मेलिटी नहीं फॉलो हुई है, इफ आउटसाइडर न्यू दैट द इंटरनल फॉर्मेलिटी इज नॉट फॉलोड, तब तो आउटसाइडर की भी गलती है. जैसे इस केस में मिस्टर जेड को नहीं पता था कि होल्ड मीटिंग के बिना उनको शेयर्स अलॉट किए जा रहे हैं. Hence, Mr. Z was protected. But if in example number 3, outsider has a knowledge कि internal formality पूरी नहीं हुई है, तब तो ये भी liable होगा. But अब बेचारे को अगर नहीं पता था, if the outsider is innocent, then there is no liability. Should have known about का मतलब है कि if it was written in somewhere there was some legal, you don't need to follow this, cut it down. बस इतना तक रखो. unless the outsider knew. If outsider knew, then outsider is liable as well. Okay, so we are done with the topic here. I hope you like my video. If you do, so do like, subscribe and share my channel. Also don't forget to ring the bell hang button so you'll get all the notifications of my channel. I'm ending the video here only. It was a small video on doctrine of interval management. It's not really a hard topic. You need to revise it. We'll do some questionnaire and then you will be pro in this. So okay, check out other videos of CA Foundation as well. I hope you like this video, and goodbye. Have a great day ahead. Stay tuned for more videos.